Lori Rolnick with the Volunteer Lawyers Project, and we're providing this update that's current as of today, Tuesday, January 12th at noon. I first want to thank Bethany Hemingway from our office, who is our tech guru and who's making all these great things happen so that we can get the word out to everyone regarding the status of the laws. Second, I want to thank you for taking the time to be here. It has been a wild ride, hasn't it? And the laws have been changing rapidly. So we really appreciate the time to briefly connect and provide a status update on current landlord-tenant legislation and tenant rights. But this brief update will in no way cover all tenant rights laws. This is simply an update regarding the newest current laws and the eviction prevention Act and moratorium that's in place now, so that everyone has a better understanding of what this means. At the end of December, the legislature and governor created the COVID-19 Emergency Eviction and Foreclosure Protection Act of 2020. This legislation does recognize the historic threat to public health that's presented by COVID-19. And the intent of the legislation is to avoid as many evictions as possible for people who are experiencing a financial hardship during the pandemic, or who cannot move due to an increased risk of severe illness from COVID-19, or are having hardship moving. All landlord-tenant proceedings that are pending or that are filed prior to January 27, 2021 are currently being adjourned for a minimum of 60 days. This is not a blanket moratorium. It is simply an adjournment, and there is a narrow exception that allows cases to continue to be heard if a petitioner is alleging persistent behavior that substantially infringes upon the use and enjoyment of other tenants or occupants or causes a substantial safety hazard to others. If a landlord has not already alleged this in a current proceeding, they must file a new and separate action that does include these allegations. Tenants also can and should, where appropriate, present their landlords and the courts with the provided declaration of hardship. The courts will be sending this out to anyone who is facing a case at this time, and landlords can also provide it to tenants. Our office also has it available on our website, and we can get a copy to anyone who needs one. The form is to be signed honestly, and it is this form or other evidence of COVID-related financial hardship that will continue to prohibit eviction until at least May 1st in most cases. A copy is again available on our website and will be linked in the Tenants' Rights Clinic volunteer materials. So if anyone is working with our volunteer Tenants' Rights Clinic, you can ask the attorney who calls you about the form. So we're asking everyone's help in getting the word out to tenants. If anyone speaks to tenants about any rental-related issue during this time, it's important and appropriate to share the information about this form with them. Please also help tenants with completing this form if they have questions. There are two parts, A and B. It's a simple 3-page form, and the first page is simply a notice about what it is. The second page, and I will show this form to everyone in a minute, but the second page, part A, it provides certain reasons why someone should be able to avoid eviction, and part B has a different reason. Check off which or both apply and then sign it. Then tenants should keep a copy of it and also provide it to their landlords. If a tenant is facing an eviction proceeding, it's important to also get a copy to the court and to any attorney who might be representing them. The courts have been directed to stay, which means to adjourn or put off all matters for 60 days. And what the Syracuse City Court is doing is adjourning the cases for these 60 days, at which point they will not immediately be holding a hearing. They will be administratively reviewing the files to see if there is evidence of COVID-related financial hardship in the written file. If not, they'll be sending new hearing notices at that time to determine whether there's a hardship or any other defenses. And if there is evidence in the file, the court will hold the case off even further with no eviction possible until May 1st. So having this form in the file is super important. This new legislation now specifically applies to both types of eviction matters, non-payment and holdover. What does that mean? I think it's important to have a brief overview of that. In New York State, there are two ways to be evicted, either for non-payment of rent, which is called appropriately a non-payment case, or because a landlord gives notice of a lease termination or non-renewal, but the tenant hasn't left. That's called a holdover case. Most cases alleging tenant lease violations or behavioral issues are also brought as holdover actions. It's important to understand the differences between the two types of cases so that you can recognize what you or your clients may be facing and what defenses might be available. And if you're reaching out to legal counsel, which again we do recommend, you can let the attorneys know what's happening exactly in this case. It's important to note that the previously enacted Tenant Safe Harbor Act still does apply. It just is going to be applying maybe a little bit differently and after this current act ends, we believe, in May. So what that act means is that a landlord cannot be allowed to evict ever on the basis of non-payment of rent during the COVID covered period, if the tenant can demonstrate that the non-payment was due to a COVID-related financial hardship. So the burden of proof in those cases is stricter than under the new Emergency Eviction and Foreclosure Prevention Act. And the burden of proof in those cases is on the tenant. Under both acts, the landlord still can get a judgment for the monetary value of the rent due. So rent is still due. Rent has not been waived, and it's important to know that. However, landlords simply can't evict for non-payment based on that rent. We really do encourage tenants to reach out to local service agencies and apply for any rental assistance that may be available to help avoid those judgments for back rent. Also, the Tenant Safe Harbor Act only prevents evictions after May 1st if the tenant can prove the non-payment of rent was due to financial hardship because of a loss of income, and that's a stricter standard that's under the new act. So let's take just a little look at this hardship declaration form. I'm going to try to figure out the sharing of this, and let me make sure I've got it. Okay. So this is the tenant, the notice, that the hardship declaration form, and it starts off as notice to tenant. And this is saying if you've had lost income or increased costs during the COVID-19 pandemic, or moving would pose a significant health risk for you or a member of your household, and you sign and give this hardship declaration to your landlord, you cannot be evicted until at least May 1st for non-payment of rent. This is that little caveat there. You may still be evicted for violating your lease by persistently and unreasonably engaging in behavior that substantially infringes on the use and enjoyment of other tenants or occupants or causes a substantial safety hazard. So this is not a blanket moratorium, but it does cover most cases. As we go down a little further, there is a part, this form that's being provided by the court system does include a part to put the index number and the city and the court, the county and the court that's hearing the case when applicable. And this line here, it's not super clear, but this line here is where you should be typing in your address. And it does come as a PDF, so you can just type it in, 220 Oak Street, or whatever it is that is your address, so that it's super clear to the court, because it is a couple of pages and we want to make sure it's all covered. So there are 5 statements in Part A, and if any one of these statements apply, you don't have to check off the numbers 1, 2, 3, 4, or 5, you just check off the box A. The first is whether you're experiencing financial hardship due to a significant loss of income during COVID, or number 2 is an increase of out-of-pocket expenses. 3 is childcare responsibilities. I mean, kids are working, doing school from home now. They need supervision and care, and some people can't work if they're responsible for watching the children, or if there's a sick family member during COVID. 4, I think, will apply to a lot of people during these crazy times. The moving expenses and difficulty in securing alternative housing would make it a hardship to move during this pandemic. 5, other circumstances have negatively affected your ability to obtain employment or earn income or reduced your income. So these 5 statements are far beyond the Tenant Safe Harbor Act protections, and also important and worth noting that the federal, you may have heard about or even signed a form with the federal CDC protections. The federal CDC Act was extended until January 31st, but this New York law is now stronger and provides better protections for tenants. So we're no longer advising people to use the CDC form. If that form is already in a case file, it should cover the same situations. But this form is so easy to use, and it'd be great to also put that. The more you can do to protect people, the better. So to put that in the file and get it to an attorney if there's a case, and to get a copy of this to your landlord because they're expecting it. Part B should be checked off if vacating the premises or moving to a new permanent housing would pose a significant health risk because either you or someone in your household has an increased risk for severe illness because of COVID, because they're either over the age of 65 or have a disability or underlying medical condition, including or not, but not limited to being immunocompromised. So check off A or B or both, sign it, date it, and get it out to all the appropriate parties and make a copy. It does note here that the signer understands that they must comply with all of the other lawful terms under the tenancy, and that fees, penalties, interest for not having paid rent may still be charged or collected, and you may have a monetary judgment held against you. I also think it's important to note under Part A that in the very beginning of this, it's, I mean, at the end of Part A, it says that you're signing an acknowledgement that to the extent that you have lost any income or had expenses because of COVID, that any additional funds or benefits that you may have received did not fully make up for the loss of those funds, the loss of the household income or increased expenses. So that's an important part of this as well. So I'm going to stop sharing this form, and as well, if anyone ever has any questions about the form itself or any questions about landlord-tenant rights, they can always contact me. I'm going to give my contact information at the end, but I will also give it here as well. My email is lrolnick, which is my name, my first initial last name, LROLNICK @onvlp.org. And my phone number is 315-930-3506. So I'm going to do that at the end. There's one more thing that I want to note because I think it's super important that tenants, landlords, service workers, and particularly any law enforcement understand is that by law, no one can make you leave your apartment without a court order. It is against the law, and it is now newly under RPAPL 768 a criminal act for a landlord or any agent of the landlord or anyone really to deprive a lawful resident of their home without going through due process. And by that, what I mean is self-help evictions, where someone who's been there lawfully for over 30 days is either threatened with force, experiences force, is harassed excessively, there's a pattern of practice of harassment, a landlord changes the locks or turns off the essential services such as power, heat, water, or just basically tries to force someone to leave without having a court order. We've even seen landlords take doors off. All of those actions are considered crimes under RPAPL 768, criminal class A misdemeanors. We are trying to get the word out to law enforcement to help protect tenants' rights during this time. So please be aware of that. A landlord cannot evict without a court order. The courts are not issuing those orders except for very limited situations. So again, if you have any other questions or even about just general landlord-tenant rights, we're always able to help. Again, my email is lrolnick, LROLNICK @onvlp.org, or my phone is 315-930-3506. Thank you all so much again, and I wish you all well during these very difficult times. Stay safe, be well. Take care.